The Ernie Chambers Show.
Brothers and sisters, friends, enemies, and neutrals, today I'm going to talk about something I did that had nothing directly to do with my being in the legislature, although there was kind of a bleeding over. I'm going to read some articles, then from a document I filed in court, then the judge's decision. When I undertake to do something, I do it the best that I can, knowing and recognizing that I don't know everything, and some things I once knew I may have forgotten. I will review the situation I'm going to confront. I don't have false modesty. I don't have false pride or foolish pride. If I'm going to confront a judicial individual or a collection of them, like on the Supreme Court, I start out with the presumption that I don't know anything, and they will know only what I say to them. So I started ground zero and worked my way on up, because as you know, every old hound dog once was a pup. Here's the first article, and it's dated June 13th, 1998, some time ago. Headline, Smile, red light runners, city to install 10 cameras to catch violators. I was opposed to this from the very beginning. Within 3 weeks, Omaha's Public Works Department will send out a request for proposals to install and operate 10 cameras that would photograph the vehicles of motorists as they run red lights. The cameras would pay for themselves and not cost the city anything, said Charlie Krejcik, city traffic engineer. Krejcik said the successful bidder for the project would provide and install the cameras, process the film, and issue notices to the violators. The cameras would be permanently installed on 14-foot poles at intersections. Camera locations and the cost of notice violations have not been determined, Krejcik said. Quote, when people run a red light, it can cause a very serious accident, he said. This will get people's attention. The whole goal is to improve safety in the street, unquote. Mayor Hal Dobb had proposed buying 4 red light cameras for $400,000 in the 1998 budget. The cameras would have been financed through grant money and moved to various intersections. Krejcik said detectors would be installed in the pavement near the intersections and linked to the traffic signal. When a vehicle goes through a red light crossing the detectors, the camera is activated, and smile, you're on candid camera. I threw that in. The camera would photograph a vehicle entering the intersection and passing through it. In each case, when the light is red, said Marty Conboy, the city prosecutor, 2 photographs of the vehicle and the notice of violation would be mailed to the owner of the car, Conboy said. The notice would be for a nuisance violation and not a criminal or traffic charge. Conboy said, in addition, the violation would not take points away from a driver's license. In researching the use of the cameras in other cities, the number of motorists running red lights dropped once the equipment was installed and it became public knowledge. Quote, it's an absolute universal reaction around the country, unquote, Conboy said. Quote, the cameras are a proven factor in dramatically reducing accidents by about 50%. Now, when I saw that, I disagreed with its being done. So I wrote a letter to the city council members and sent a copy to the mayor, the city attorney, and it was dealing with the unconstitutional ordinance and saying that it should be rescinded or taken back. The ordinance passed by the council authorizes use of cameras, quote, for the detection and enforcement of traffic signal violations, unquote. It is unequivocally, absolutely, positively, hopelessly, glaringly, unquestionably unconstitutional. It breaches the Constitution and statutes in so many regards that I shall address only a few. Quite frankly, I feel like a man with a scattergun shooting fish in a little barrel. However, I shall pursue a methodical, logical course and demonstrate the necessity of overturning the ordinance if the council is to behave in a reasonable, prudent manner. I declare at the outset that this memorandum foreshadows the case I am prepared to file in court to overturn the ordinance if the council refuses to act. In 1995, because the mayor and then president of the council, Lee Terry Jr., refused to ensure enforcement of the administrative license revocation law, I filed a successful mandamus lawsuit compelling enforcement, and it cost the taxpayers nearly $4,000 in attorney fees and court costs. Citizens should not be compelled to seek court intervention to obtain appropriate action by elected officials, but I'll do it. And this is not one of the ordinary duties associated with being a legislator, but as I've said, when I gave my affirmation that I discharge the duties of that office to the best of my ability, I meant it. It didn't just mean what went on during debate on the floor of the legislature, during proceedings in the committee room. It meant all the time when something affected the public welfare, I would use whatever means at my disposal to correct it and protect the public, whoever would be a member of the public, regardless of race, creed, color, sexual orientation, or any other consideration. And I am and have been a force to be reckoned with, but they never wanted to accept it. Continuing. The mayor's transmittal letter to the council stated in pertinent part, quote, transmitted herewith is an ordinance to amend portions of Chapter 2, 18, and 36 of the Omaha Municipal Code dealing with vehicles being used in a manner constituting a nuisance and with the use of camera equipment for the detection and enforcement of traffic signal violations, to provide administrative penalties for such violations and for appeals regarding the same, specifically to amend the specified sections of the Omaha Municipal Code to add new sections to the Omaha Code and a few other technical comments that he made. The conclusion, the council should give careful consideration, this is my conclusion, to the contents of this memorandum, then rescind the ordinance. I have no doubt that I will prevail in court if it becomes necessary for me to file suit for the purpose of having the ordinance declared unconstitutional. The Constitution, statutes, and case law support the rescinding of the ordinance. I went on to try to persuade the council, got nowhere. So then, to let the public know what I was about, I submitted this that I'm going to read to the World Herald. It's a type of citizen participation called Another Point of View, and it contains legal and constitutional arguments. The headline, Intersection Cameras Raise Legal Issues, and it's dated September 17th, 1998. The headline of the September 4th editorial, taking pictures at intersections is not an assault on freedom, quote, should have declared it is an assault on the Constitution, unquote. I have no quarrel with ticketing, prosecuting, and fining drivers who run red lights, but I strenuously object to shifting guilt to a person, the vehicle owner, who did not commit the offense. I fully agree with the editorialist's observation, quote, the running of red lights is a problem in Omaha. Dispatching enough police officers to watch all the problem intersections and still enforce other traffic rules would be a questionable use of manpower, unquote, from the editorial. But I disagree with, quote, using cameras to watch an intersection is simply a more efficient way to do essentially the same thing. There should be no fuss about their use. With that in the editorial, I disagree. In the name of efficiency, should we countenance warrantless searches and seizures, arrests without probable cause, detention without charges, and confessions extracted through torture? The state's constitution and laws say no to all of these depredations and no to the execrable, that's one of those highfalutin words, red light ordinance. Despite the emotional allure, the Constitution and laws may not be dispensed with in the name of efficiency to get the bad actors. As alluded to by the editorialist, I am preparing a lawsuit to challenge the constitutionality of the ordinance, and herein I shall neither argue the entire case nor raise all issues, but I'll present enough facts and law to demonstrate that more is at stake than a traffic ticket and a fine. Crimes and due process. The Nebraska Supreme Court has ruled that a traffic violation is a crime and the resulting trial is a criminal proceeding. This means that an accused must be accorded the full panoply of due process rights, including being properly charged, granted access to the courts with the attendant right of appeal, presumption of innocence, confrontation of witnesses, and proof of guilt beyond a reasonable doubt. The ordinance presumes to mislabel the offense as a nuisance. This would deny access to the courts and circumvent judicial involvement by substituting an administrative process which reduces the standard of proof to a mere preponderance of the evidence. And a person other than the perpetrator may be deemed guilty, fined, and exposed to impoundment of his or her vehicle. Point system. State law requires that all moving violations with specified exceptions result in assessment of points against the license of the operator of the vehicle. The ordinance purports to negate state law by making a fine the sole sanction and no points against the license. Fines and penalties. The Nebraska Constitution mandates that all fines and penalties be used exclusively for the support of the common schools, and no portion may be diverted to any other purpose. The ordinance diverts the fine to a private party. Supremacy of state law. A statute says that traffic laws are to be uniform throughout the state and that, quote, no local authority shall enact any ordinance directly contrary to state law unless expressly authorized by the legislature. The legislature has not authorized any city to enact an ordinance that makes a crime to make a crime a non-crime, negate the point system, or authorize the punishments in conflict with state law. No source empowers any city to do these particular things. Deny access to the courts and due process rights, shift guilt to the innocent, reduce the standard of proof in criminal proceedings, reverse the Supreme Court's ruling that traffic violations are crimes, or circumvent the constitutional mandate that all fines and penalties be used exclusively to support the common schools. I shall prevail in court and thereby vindicate the Constitution and laws. That made no difference, and I'm sure that it was read by the public officials. This article is dated December of 1998. Chambers files lawsuit to stop traffic cameras. A city ordinance seeking to catch red light violators with strategically placed traffic cameras is illegal and unconstitutional, State Senator Ernie Chambers of Omaha said in a lawsuit filed Thursday. The lawsuit filed in Douglas County District Court seeks a declaratory judgment finding the ordinance passed by the City Council August 11th, quote, illegal, invalid, and unconstitutional in its entirety, unquote. Chambers alleges the City Council exceeded its authority by passing the ordinance, saying only the legislature has the power to define traffic infractions because they are of statewide concern, and to set a schedule of punishments for violations of traffic control devices. Chambers also wants a judge to stop the city from implementing the ordinance and spending any money on the cameras. City Attorney Paul Kratz said Thursday that the ordinance was drafted in a manner to avoid the legal and constitutional flaws Chambers alleges. In his lawsuit, Chambers alleges that the ordinance violates the due process rights of citizens trying to appeal the notice of violation. It requires citizens to appeal first to an examiner and, if dissatisfied with the examiner's decision, to an administrative hearing officer. Reasons for granting or denying a review hearing are not articulated in the ordinance, Chambers said. The suit says the ordinance assumes guilt of the owner of the vehicle and renders the identity of the actual driver irrelevant. Attorney Kratz for the city said the city will defend the ordinance in court. He said the ordinance technically made the running of a red light a nuisance rather than a traffic violation. Quote, it's a nuisance ordinance, not a traffic ordinance. The car has created a nuisance once you run a red light, Kratz said. I'm confident it will pass constitutional challenge. So what I filed was a petition for declaratory judgment and injunctive relief. And some of it says, this action, by the way, I could have practiced law even before I graduated from law school if it was based on knowledge. When I went into law school, I didn't enter with the notion that I knew everything that needed to be known to practice law. I knew there was much in the law books. There would be valuable things stated by the professors, which would assist anybody who would be a neophyte or somebody just entering the practice of law. So I went there with an open mind, and my mind is like a sponge, not soft-headed, when it comes to acquiring knowledge. I'm willing to absorb, in the same way that sponge will absorb a liquid, all of those things that I deem to be of value and significance. So I read the textbooks. I missed a lot of classes because my reading of the textbook always put me ahead of what was being discussed in class, but I would periodically go. Nothing was said about that at first because being a freshman in law school, it was deemed by the professors that with the number of classes I missed, I couldn't possibly pass, and I was the only Black student in the law school at Creighton anyway, so why not just kill two birds with one stone, so to speak? Get me out of law school, make it all white, and everything could roll along as it had. But when I took the exams, I came out number 4 on the dean's academic list. I read the textbook, I absorbed what was said. That enabled me to answer all of the questions that were presented. So I knew what I was doing when I filed this petition. Nature of the action. This action seeks a declaratory judgment finding that this ordinance enacted by the Omaha City Council is illegal, invalid, and unconstitutional in its entirety. Further, this action seeks A, to enjoin or prevent the City of Omaha and its officials and employees from implementing and enforcing the ordinance, and B, from illegally spending money to implement and enforce this ordinance. Such expenditure would be illegal because the ordinance violates, among other provisions of law, the due process and equal protection clauses of the constitutions of the United States at Amendment 14 and the state of Nebraska, Article 1, Section 3, respectively. Jurisdiction and venue. I pointed out why this court would have jurisdiction over the proceedings. The parties. The plaintiff, me, is a resident of the city of Omaha, a taxpayer, and a registered voter. The defendant is a municipal corporation of the metropolitan class, organized and existing under and by virtue of the Constitution and laws of the state of Nebraska, and is governed by a home rule charter. I crossed every T, I dotted every I, and some of the lawyers who read this said it was one of the best written petitions they had encountered. Factual basis of the action. On August 11th, 1998, the Omaha City Council passed this ordinance, and it gives the number, with an effective date 15 days from and after its passage. August 26, 1988 would be that date. The ordinance addresses the traffic infraction of, quote, running a red light, unquote. Its stated purpose, its purposes are to declare traffic signal violations a nuisance and to authorize the use of camera equipment for the detection and enforcement of traffic signal violations, to provide administrative penalties for such violations and for administrative appeals regarding the same. A true and accurate copy of the ordinance is attached here to as Exhibit A and so forth. Cause of action and claims. I'm not going to read them all. The city has spent and will spend additional funds, the precise amount of which is not susceptible of ascertainment with exactitude, for the purpose of implementing and enforcing the ordinance. Expenditure of funds to implement and enforce the ordinance would be illegal. A resident taxpayer is entitled to maintain an action to prevent that, the word actually is enjoin the illegal expenditure of money by a public board or officer. Then I went on about using this methodology to detect violators and proceed when the statute placed that responsibility in the hands of law enforcement officers. It talked about the hearing process as opposed to a court proceeding, the absence or the withholding of certain constitutionally guaranteed rights, and then it comes to a drafting peculiarity. The final sentence in Section 5 of the ordinance says, the owner may appeal the decision of the administrative hearing officer as provided in the given section, which section merely empowers the Administrative Appeals Board to, quote, hear or review all appeals in cases of administrative hearing for violations of this particular section. However, the procedures and requirements for filing an appeal are found in a different section. Since the ordinance explicitly limits the bringing of appeals to the provisions in the other section, no procedural steps are available to effectuate an appeal of this ordinance. Therefore, the opportunity to appeal has been wiped out. I read what is written and take the words literally. The presumption of innocence is replaced by a presumption of guilt, and such presumed or unproved guilt can be shifted from the actual perpetrator to an innocent party, the owner of the vehicle, who had no role whatsoever in the violation. Guilt is presumed and punishment imposed without a hearing unless such presumed guilty party, in violation of the constitutional right to remain silent, speaks in writing and overcomes the presumption of guilt without having been provided notice of what factors must be proved or established in order to overcome this presumption. And under the U.S. and state constitution, guilt is not presumed. A person is presumed innocent until proved guilty. The whole burden is on the state. This turns that upside down and says that the person is presumed guilty and must overcome that presumption of guilt. The ordinance renders the identity of the actual perpetrator totally irrelevant for all purposes. The ordinance declares that payment of the assessment shall be the exclusive remedy for such violations for the owner and the operator of the vehicle. And the owner could have his or her vehicle confiscated for failure to do what they want this one presumed guilty to do, even though he or she was not driving. The car could have been stolen. The car could have been loaned to somebody else. And the driver, whose identity is unknown, can be out of the picture entirely. This has the practical effect of nullifying state statutes relative to punishment of infractions, and I gave the citations, as well as the statutory point system, and gave the citation. This ordinance said no points would be taken from the license. The city council calls itself amending the state statute by repealing the point system, which obviously it doesn't have the power to do. Now remember this, they had a white lawyer doing all of this. All the council members at that time were white. And then here's one black man who reads the law, their white people's law. And it was necessary for me to get involved in what I call white folks' mess because of the incompetence, the ignorance, the arrogance, the feeling of privilege of white people, even in elective office where the conditions of that office are set forth. They feel they don't have to comply with that. All they have to do is say it and it becomes so. Well, this is one black man who did not accept that, and I was going to embarrass them. So I went on and on. I'm skipping some of these things. There were so many statutes that they violated, and I don't want this to be something that will cause me to lose whatever viewers I may have because it becomes too technical. But here's something that might be of interest. Utilization of unattended camera equipment for the detection and enforcement of traffic signal violations is in direct conflict with, and I give the section of statute, which makes it the explicit duty of peace officers to handle such enforcement. Providing penalties in the form of administrative assessments for traffic signal infractions, which are in fact crimes, is in direct violation of, and I give the section, which has established criminal penalties. The substitution of an administrative process for judicial proceedings, which are guaranteed to every accused person, violates the constitutions of the United States and the state of Nebraska. I'm having to give them a lesson in their white folks' law, and I'm a black man even to this day because of being black and presumed to be inferior to them. That's some more white folks' mess, and it's why they're against what is called critical race theory. All critical race theory does is say that racism affects all of the institutions in America, whether judicial, legislative, or administrative. We know this from experience, from trying to get a job, to purchasing insurance, to getting equivalent medical care, even though we have the coverage. It's all affected by our race. There are certain ailments such as kidney diseases, which put in what is called an algorithm that says that black people's kidneys function differently from white people. So we don't need to be on a kidney transplant registry as soon as white people, because we can function with what is diagnosed as bad kidneys longer than white people without it affecting us negatively. How can that be? It goes against science and medical knowledge, but our being black leads them to create fictions. When this African doctor made the discovery that the concussions that these football players were receiving while playing the game affected their brain and actually created a new disease, and white people didn't want to accept it. So he began to dissect brains and found physical differences in the brains of those who had suffered these concussions and the brains of those who had not. That was something the NFL didn't like, because when a person leaves football due to an injury, the amount of compensation is based on the amount of injury or the degree to which the injury reduces a person's ability to function. Well, they put into that equation what they call they didn't call it this, but it was, quote, the Negro component. It was based on the notion that Black people's brains, my brain, who seems to be more capable than all these white people's brains put together, starts out functioning at a lower level than a white brain. The white man's brain is up here, mine is here. So when we both get here, there's less injury to me because I started at a lower level. I lost less brain usage because I didn't start out with as much. On the other hand, the white player who starts out here, up here with brain capability, and then came down here and we both on the level, the white man got a bigger amount in terms of compensation for that injury because more brain power was lost. This African doctor demonstrated that not to be the case. The NFL didn't want to accept it. The NFL doctors had gone along with this racial component. To make a long story short, the change had to come. And now they're having to upgrade the amount of compensation paid to the player, if that player still is alive, it shortened their lives, or the player's survivors. And white people don't like this, but they had to pay the piper because a Black man forced their hand. This white ordinance was nullified because a Black man who was generally hated came to the rescue of all people, including white people. And I'm going to start giving concrete examples of things that I did that protected people and white people that they don't even know about. That was a digression to demonstrate that were it not for Black people, there are a lot of bad things that would be happening to people in this society, worse to us because we're Black and always considered at the bottom of the barrel, but bad for white people. What these racists will not look at is the fact that if Black people are worse off, and we are, then when you raise the barrel, you raise everything in it. You cannot lift us without lifting everybody else. Or as they say, a rising tide lifts all ships. You all have no idea of how tiresome, irritating it was for me during more than 4 decades, 46 years, educating these ignorant white people about their Constitution, their laws, their legislative procedures. I gave them lessons daily in their legislative rules that they put in place to stop me. I got around the rules, and the rules trapped them. I was like Jesus, Ernie, what must we do to be saved? Then I told, well, let me do it in a way that white people can understand if any are watching this. And I'm doing it this way on purpose. Now they take offense at this and say how hurtful it is to them. I'm not calling their little children little cracker peckerwood. I'm not sending them to unequal schools with incompetent teachers. None of that am I doing. I'm talking to grown white people and their little feelings get hurt and they say, see there? And they run everything, the courts, the legislature, the police departments, everything. And they cannot deal with a Black man who's merely using words that comprise their language. I don't know what my language would be if my ancestors had not been dragged out of Africa, speak their language better than they do. And that offends them. Well, then let them study like I study. Let them learn what I learn. The same dictionaries available to me are available to them. The rule book is something that each member of the legislature gets. We couldn't even get expenses during session until I brought a law and forced the Attorney General to challenge it in court. And I won. And as a result, legislators received expenses connected with being in the legislature while we're in session. And for senators in outstate Nebraska, it gave them more in the way of remuneration than the salary they received. That's what a black man did. White employees of the legislature did not get a long Easter weekend until I looked at it as a member of the executive board and said, this is not right. These employees will get that long weekend. And their long weekend ran from Saturday to Tuesday. Friday. They got Friday before Easter and Monday after Easter off as paid holidays, which they hadn't before. And for all employees who were female, and the vast majority were white, they'd pay the same percentage of their salary into the pension fund, that when time came to collect that pension payout, once they retired, they got less than the white men, because the insurance industry said, well, since women live longer than men, actuarially, it won't make sense to give them the same payout as you give the men, because women live longer. And this was brought to my attention by a black woman, Cynthia Granberry, who was going to law school at that time, and found out that's what was going on. And as soon as I heard it, I said, this is so wrong, I have to correct it. And to make a long story short, that's what I did. I said, first of all, not every woman lives longer than every man. And when they go to the store, groceries don't cost them less because they're getting a lesser payout under the pension program. There were white men before me. They hadn't done any of these things. And there were other things that I did relative to white female athletes, because most of them at the university were white. White female coaches. You all don't know about it because white people are not going to tell you about it. To you, I'm the troublemaker. I make trouble for them. I afflict the comfortable and I comfort the afflicted. They give homage to the rich and powerful. I give my protection to the least, the last, and the lost, whether they know it or not. And I don't look for thanks. I don't look for anything other when I'm operating legislatively than my salary. I accepted no gifts, no campaign contributions, nothing, nada, zilch, zero. I was one of a kind. And then after I left, they called me an icon. They called me one of a kind. They even called me a legend. But all I am is just who I am. But continuing, it's a poor car that won't toot its own horn occasionally, wouldn't you agree? I went through all of this and laid out all of these counts, and I won't have time to read them all, and I don't intend to. But it went on and on and on. I want to get my pages in order here, so that when I leave and get back home, I will know that I've got everything that I should have. And I don't think you all mind me doing this. I've earned that right, haven't I? And who knows, if you listen, you might pick up on something. I'm separating out what I did. And now let's look at the order that the white judge gave. The city filed an answer to mine, pointed out what they said were my errors and that I should not win. Here's what the judge said in her order. This matter came on for hearing on December 29, 1998. We had the hearing and I argued my case in court. On the plaintiff's request for a temporary restraining order. The plaintiff appeared pro se and the defendant appeared through Alan M. Thielen and Martin Conboy, 2 against 1. And they thought it was 3 against 1 because there was a white judge. Exhibits 1 through 3 were offered into evidence by the plaintiff, me. Exhibit 1 was received and the court reserved ruling on exhibits 2 and 3. The court knew that I offered so much information, some of it would not be necessary. We wouldn't even have to go that deep into the ground to reach a decision. Arguments were then presented by the parties and the matter was taken under advisement. The court has reviewed the evidence, arguments, and authorities presented by the parties and being fully advised on the premises and finds as follows. The plaintiff, Ernie Chambers, filed this action on December 3rd, 1998, seeking a declaratory judgment finding that this ordinance, hereinafter the ordinance, enacted by the Omaha City Council on August 11, 1998, is invalid and unconstitutional. The ordinance was enacted to address the problem of motorists running red lights at various intersections throughout the city of Omaha. According to the provisions of that ordinance, photographic equipment would be set up at certain intersections. If a motorist runs through the red light at a certain intersection, a photograph would automatically be taken and the license plate of the violating individual, a vehicle. A citation would then be sent to the owner of the vehicle, who would then have the opportunity to come forward and challenge the citation before an administrative hearing officer. The ordinance provides that running a red light is a public nuisance and a civil offense. The city would establish by a preponderance of the evidence the liability of the owner. The plaintiff has challenged the validity and the constitutionality of this ordinance and has requested a temporary injunction. Then she cites the statute. When it appears by the petition that the plaintiff is entitled to the relief demanded and such relief or any part thereof consists in restraining the commission or continuance of some act, the commission or continuance of which during the litigation would produce great and irreparable injury to the plaintiff, or when during the litigation it appears that the defendant is doing or threatens or is about to do or is procuring or suffering to be done some act in violation of the plaintiff's rights respecting the subject of the action and tending to render the judgment ineffectual, a temporary injunction may be granted to restrain such act subject to the limitations of these various statutes. It may also be granted in any case where it is specifically authorized by statute. She quoted that. Then she continues, the Nebraska Supreme Court has specifically held that the state has the primary authority in the area of relating traffic. And she gave a statute. The state has inherent power to establish, maintain, and control the highways of the state, including those within corporate limits of the municipalities. While the legislature may properly delegate certain powers over streets, alleys, and highways to municipalities, it retains the power to legislate with reference thereto, even in home rule cities such as Omaha, when a matter of statewide policy and concern is involved. She cited that statute. Nebraska revised statute, reissue, and she gave another citation. Quote, the Nebraska rules of the road shall be applicable and uniform throughout the state and in all political subdivisions and municipalities of this state, and no legal authority shall enact or enforce any ordinance directly contrary to the Nebraska rules of the road unless expressly authorized by the legislature. And guess where she got these quotes? From this petition that I filed, which I didn't read all of because it would simply be repeated in her order. Where there is a direct conflict between a city ordinance and a state statute, the statute is the superior law. A city ordinance is inconsistent with the statute if it is contradictory in the sense that the two legislative provisions cannot coexist. Generally, an ordinance cannot prohibit what the legislature has expressly licensed, authorized, or permitted. Therefore, in order for the city to adopt an ordinance, there must not be a direct conflict between the ordinance and the state statute. According to the provisions of the ordinance, and then she read, as I laid it out in my petition, the following: running through a red light at an intersection constitutes a nuisance and a civil offense with civil penalties and a civil burden of proof. The state statute provides that a violation of the Nebraska rules of the law shall constitute a traffic infraction. The Nebraska Supreme Court has stated that violation of a traffic infraction is a crime. A crime has criminal penalties, and the alleged violator is provided certain constitutional protections afforded persons charged with committing a crime, including a burden of proof of beyond a reasonable doubt, which is my argument, and she's putting it in here. And then she quoted from the case that I laid out, and this is what the court said. After analyzing the Nebraska rules of the road, it found that the words used were associated with criminal law, and they conclusively showed that a traffic violation was a crime and the proceeding was criminal. Because the traffic infraction is considered a crime pursuant to state statute, it is inconsistent for the city to adopt an ordinance declaring the same traffic infraction to be a civil offense. A direct conflict exists between the ordinance and the state statutes. The state statute is the superior law, and the ordinance is invalid due to the lack of the city's power and authority to enact such local legislation which conflicts on its face with the state statute. The judges who dealt with what I presented liked it, and they had mentioned it to lawyers, and lawyers got the word back to me because they could just go by my arguments and write their order based on that, because I cited the statute, the Constitution, both federal and state were involved, the state statutes, and then showed where the city's action conflicted. Well, why reinvent the wheel? I gave the wheel, the purpose of the wheel is to roll, and what I wrote was rolling along, so the court just went along for the ride. A direct conflict exists between the ordinance and the state statutes. The state statute is the superior law, and the ordinance is invalid. The city submits that several other jurisdictions have enacted similar ordinances utilizing photographic equipment and doing some other things. Further, the city claims that this ordinance was specifically modeled after the ordinance adopted by Charlotte, North Carolina, and then they told what Charlotte's ordinance did. And the court pointed out that enabling statute in Charlotte, North Carolina, specifically allows municipalities to adopt ordinances with civil enforcements by means of traffic control systems. That enabling statute clearly distinguishes the present ordinance adopted by the city of Omaha from that adopted by Charlotte. The Nebraska State Legislature has not yet enacted any similar enabling statute. So what the city offered as its argument against mine really proved my argument and knocked theirs out of the ballpark. This is white folks' mess that I have to deal with. They're the smart people. They had not only two lawyers, the city attorney and the city prosecutor, and a legal staff. And there was just poor, pitiful me. But what poor, pitiful me did was to read and understand the constitutions of the United States and the state of Nebraska, the state statutes. I can read, I understand what I read, and I know how to present a legal brief. Continuing, the Nebraska State Legislature has not yet provided an enabling statute in this case, and there is no broad general grant of authority by the state to permit the city to adopt a traffic ordinance which utilizes photographic systems and provides for civil penalties. The city of Omaha has exceeded its authority by adopting an ordinance that conflicts with the applicable state statutes. Even if this court had found that the city was acting within its authority by adopting the ordinance, it would still fail because one of its provisions violates the Constitution of Nebraska. Article 7, Section 5 of the Constitution provides in pertinent part as follows: all fines arising under the rules, bylaws, or ordinance of cities shall be appropriated exclusively to the use and support of the common schools in the respective subdivisions where the same may accrue. And as I pointed out, according to the provisions of the city's ordinance, quote, any person as the owner or operator of a motor vehicle in violation of this section shall pay an administrative fee of $55 plus a handling cost of $30, and when assessed, shall be the exclusive remedy for such violation for the owner and operator of such vehicle. The Nebraska Supreme Court has previously stated that a fee schedule that allots a portion of the money to cover administrative costs is in violation of the Nebraska Constitution that requires all fines and penalties to be appropriated to the use and support of the schools, which I quoted. The defendant, City of Omaha, attempted to use a portion of the fines collected from parking violations to cover administrative costs. The court held in that case that the defendant was not allowed to divert any of the penalties away from the schools. Because the city has declared that a portion of the penalty assessed under the ordinance would be used to cover administrative costs, the ordinance is in direct violation of the Nebraska Constitution and cannot stand. In his petition for declaratory judgment and injunctive relief, the plaintiff has included 18 counts. The court has decided this controversy on the basis of two issues, which are dispositive of this matter, and therefore it is not necessary to address plaintiff's remaining arguments. In other words, the first 2 points that I made were enough, and all that other was unnecessary. It's like saying, when you shoot that cow in the head, you don't need to use the rest of the bullets that you might have in an AR-15. That one did the job. Concluding, it appears by the petition that the plaintiff is entitled to the relief demanded, and unless a preliminary injunction is entered at this time, the commission or continuation of some act by the defendant, the city, during this litigation would produce great or irreparable injury to the plaintiff. Pursuant to section, and then it gives the sections of statute, a bond is set at $100 to be paid by plaintiff to the clerk of the district court. That's to cover any charge costs that may accrue in case additional action takes place. It is therefore ordered, adjudged, and decreed that the defendant, City of Omaha, is hereby temporarily and preliminary enjoined directly and indirectly from implementing and enforcing this ordinance enacted by the City Council. It is further ordered and adjudged and decreed that this preliminary injunction will remain in full force and effect until further order of this court. Then the World Herald wrote an article, traffic cameras hit snag, and they describe what happened in court. And after looking at everything that had been done, this is a letter I got from the city council. I mean, the city attorney. regarding Ernie Chambers versus City of Omaha. Dear Senator Chambers, on April 27, 1999, the Omaha City Council rescinded the ordinance which was the subject of the above referenced case. I enclose a certified copy of the ordinance with the endorsement at the end noting that it has been rescinded on that date. Since the city has rescinded the ordinance and the subject of the litigation no longer exists, I would propose a joint motion to dismiss the pending lawsuit. I enclose for that purpose a proposed dismissal order. If you agree that the action should be dismissed, please sign and return the order, and I will present it to Judge Lamberty. If you disagree with the proposed order, please contact me. Thank you for your cooperation. And I could have put them through more trouble, but I didn't. When what I wanted to accomplish had been accomplished, there was no need for me to go further. And here is something that was written by the World Herald a couple of years later when the state of Nebraska was going to enact a statute to allow the city to do this, and I attacked it. And here's what the editorial said. Don't shelve the camera bill, save it. Nebraska State Senator Ernie Chambers says a bill that would let Omaha cities use cameras to catch red light runners is unconstitutional because it violates constitutional equal protection doctrines. He may be onto something. Red light violators nabbed by police would lose driver's license points, whereas those spotted by cameras would not. Lawmakers would do well to take heed. Chambers, who holds a law degree, has in the past demonstrated insight into such issues. 3 years ago, he told Omaha its new red light camera ordinance was unconstitutional because it defined the violation as a civil matter, whereas the state law makes it a crime. Chambers went to court and won. Thus, there is still no such law or ordinance. The best solution, though, probably is not to shelve the bill for yet another session. The preferable way is to fix it. For years, proponents of such a measure, including this newspaper, have seen the license point disparity as a way to make this a kinder, gentler red light law. Perhaps it is time to drop such niceties and stop objections like Chambers by fully harmonizing the penalties, points, and all. Such a measure might or might not pass, but it can't hurt to find out. We won't belabor again today, and then they talk about statistics and so forth, but the World Herald had to acknowledge that I have a law degree, that I understand the law, that I whipped the city of Omaha, that I raised a valid constitutional issue on this statute that the legislature itself was trying to enact to help the city do this. And they said they needed to pay attention because I showed what I knew. White people cannot listen to a black man. If instead of fighting me, they would talk to me, not only would they save themselves embarrassment again, I would help them put together a fair and just law. I told them that my job is not just to try to enact just, reasonable, equitable laws, but to prevent the passage of laws that would be hurtful to the public. The public is not sitting in the legislature. The public does not attend, all of the public does not attend committee hearings. All they know is that there are laws in the law books and don't know what those laws are until they run afoul of one of them and will have to go to court. And then I point out to my colleagues, when you all bring these proposals that somebody else gave you, and I question you, and you cannot give the answer, I always ask you this follow-up question. If you who are bringing the law and asking that it be enacted into law by being placed in the statute books after we vote and the governor signs it, if you don't know what the law means, why will you put this on your white fellow citizen? I said, you don't care about me and mine, because despite what the Constitution clearly says and is upheld by the U.S. Supreme Court, those things are not applied to us equitably. We are not entitled to life. Ask any cop. who wants to take our life. Liberty, not entitled to that. Ask any prosecutor who wants to bring some trumped up charges, a judge who will accept them, then illegally incarcerate us for maybe 2 decades before they finally find out, because some group who had enough concern will bring information that was available at the time of the trial, and 2 decades later, after we've lost 20 years of our life and some have died, they say, well, the joke's on us, we made a mistake. It's not a joke, and it wasn't a mistake. It was an evil deed done with malice aforethought based on racism. So when these white people want to pretend that racism is a dead thing, they say that to try to give these Negroes, and I use that term pejoratively, who have a job dependent on white people's approval, it gives them a leg to stand on so that they can say, well, racism, hey, it ain't what it used to be. It's like these Negroes who are saying we're at a post-racial period in history because President Obama was elected. Post-racial means that you're past the point where race makes any difference. And I mocked them, I scoffed, and I told them how foolish they were. And all of those who were saying that had jobs with white people. Some were employed directly or indirectly by Susie Buffett and on down the line. Some held jobs like the head of the Urban League and things such as that. And there I was, that contrary voice crying in the wilderness and listened to by nobody, heard, if anybody hears it, by the beasts of the field, by the crickets at night, and the grasshoppers by day, and the birds that fly over, and those for whom it was intended, excuse me, will not heed. Well, if you don't pay attention to the caution sign, you run into the problem that you're being cautioned about. If the sign says road out due to flood, and you ignore that warning and you drive on, your car sinks in the water and you may drown. I cannot cease raising the issue of racism and discrimination because those things continue to exist. We're fighting what the people in the Deep South decades ago were fighting during the so-called demonstrations during the 60s, the right to vote. These white people are trying to streamline it now. They make it difficult to register, difficult to get to a polling place. Sometimes your precinct is altered and you don't get notice of it. Every way they can to prevent us from voting, they do it. There are laws in the South on the books right now where if people have been waiting a long time in line to vote in person on a hot day and you give somebody a drink of water, you have violated the law. Yeah, that's what these white people are doing. The ones who want to say that there's no such thing as racism. Critical race theory is not in our schools and it shouldn't be there. Well, what they're talking about, because they're so ignorant, critical race theory is not in the grade or high schools. It's in the postgraduate, at the postgraduate level. That means even after college at some universities. But at a minimum, it's not taught or discussed until you get into college. No high school teaches it. These white people think because the word critical is in it, that it's going to talk about what their ancestors and so-called founding fathers of this country did. When I was in the legislature, I mentioned it again and again. Not to criticize and condemn our two brothers who are in the legislature right now. But when a bill was converted into law and passed, it had to do with teaching about those attempts to wipe people out. And there's a word for it, genocides. And that's when you commit such violations against a group of people that in effect you're trying to annihilate them. Well, they had a bill like that to require the teaching of about the Holocaust. Justin Wayne managed to offer an amendment that was adopted that said they should talk about the horrible things that happened to Black people. And he mentioned the Tulsa massacre, where hundreds of Black people were killed, where what was known officially as Black Wall Street was literally destroyed. There were fire bombs dropped from airplanes on Black people who were civilians in America. And Justin presented some of these things, and the amendment was attached to the bill. But then, because these racists have the power, they said, well, if you don't take that out, the bill won't pass, talking to their fellow racists. So the white people voted to eliminate that from the school's ability to teach it, and certainly not a requirement to teach it as it is with the Holocaust, which didn't occur in the United States. And then they passed the bill and the governor signed it, and the governor said he would not sign it with that provision in it. Well, I would have said, had I been there, and I demonstrated it time and time again, if the ship that I'm captaining is not allowed to leave port, no ships are going to leave port. And they knew I was not bluffing. Not only would I fight against the bill that was before us, I would fight other bills and tell them, you may not get to this one again because we're going to spend all the time on these bills that are backed up, that mean as much to you as this one that I'm concerned about means to me. And you don't believe me? Try me. Tomorrow when we start at 9 o'clock, why don't we change that starting time to 8 o'clock? And why don't we eliminate a break for lunch, a recess for dinner? And let's stay here from 8 o'clock in the morning until midnight. And you can go a minute past midnight if you want to, but because you all are so dumb, you try to show me something. But if you go 1 minute past midnight, that becomes another legislative day. And you're certainly not going to stay here for a full day. I shouldn't even tell you that and let you go 1 minute past midnight, and you've lost this day that I've held you here from 8 in the morning till midnight, but I took the following day from you because you're so dumb. You didn't realize that when I took you 1 minute past midnight, that's another legislative day you lose, and I don't have to deal with you on that day. That's how I beat them by their rules, because I knew the rules and they didn't. I read English and I understand it. They would employ words, the meaning of which they had no concept of. So then some got a little savvy and they'd say, Ernie, can you help me with this? And I tell them, I'll deal with you the way you deal with me. On this over here that I'm interested in, until something is done with that, don't ask me for anything. Why should I strengthen the hand that holds a club that will be raised against me? You think I'm as stupid as you are. Do it yourself. But on the other hand, I would tell them, this morning, we can fight like scorpions in a bottle. But this afternoon, if you're on the right path and we're going the right direction, moving the same direction in one accord, we'll cooperate. And I will carry that ball across the finish line. I had an awareness of what my job was, and I did it to the best of my ability. And it was considerable. And at this point, I'm going to end it in the way that I always do if I remember. As the canary said when they told him that the door to the cage was open, I'm out of here.
Thank you for watching the Ernie Chambers Show. If you'd like to make suggestions, email us at ewcfacts@gmail.com. That's ewcfacts@gmail.com. This has been an EWC Communication production.